Welcome to this explainer. Today, we're diving into something that sounds incredibly dry but is actually absolutely crucial for your business: FEMA compliance in India. Basically, if you're trading internationally, taking foreign investment, or sending money abroad, you are playing right in the RBI's sandbox. And let me tell you, missing a step here doesn't just cause a minor headache, it can literally freeze your funding. Let's get right into it.
Here is a quick rundown of our agenda for today. First, why compliance matters. Second, the rules for FDI, ECB, and ODI. Third, the mandatory forms you absolutely need to know. Fourth, the RBI's monitoring role. And number 5, how to maintain ongoing compliance.
All right, Section 1. Why FEMA compliance matters, or as we like to call it, the shift from fear to cooperation.
To understand why a single missed filing can completely derail your next funding round, we kind of have to look back at history. Talk to any industry veteran, and they might actually whisper when they mention FERA, the old Foreign Exchange Regulation Act. FERA treated foreign exchange like a state secret. Violations were criminal offenses, and honestly, it bred a culture of fear. But today, we operate under FEMA. The M stands for management. It operates on the assumption that capital should flow freely. Violations are now treated as civil wrongs, so the whole system is focused much more on cooperation and correction rather than, throwing founders in jail.
So what is FEMA compliance exactly? At its core, it's the mandatory adherence to the rules, reporting formats, and strict timelines set out by both the RBI and the Ministry of Finance. It applies to literally every single cross-border transaction. Whether you're an Indian startup receiving foreign investment or just an individual remitting funds abroad, you have to comply. It's how you protect your business and the broader integrity of India's economy.
A really great way to ground all this legal jargon is to just use a tax analogy. We all know we've got to file our taxes accurately and on time, right? Well, FEMA operates on the exact same logic. Just like your corporate taxes, the FEMA system heavily rewards precise accuracy and severely punishes any delay. The clock is basically always ticking. The longer you wait to report a transaction, the more expensive that mistake becomes. To truly grasp compliance without getting completely overwhelmed, you just need to remember this rule of 3. Compliance isn't just one single thing. It actually happens in 3 layers. First, the transactional layer. Are you even allowed to do this deal under current routes and limits? Second, reporting. Did you actually submit the correct forms to the RBI on time? And third, the documentary layer. If an auditor knocks on your door tomorrow morning, is your paperwork bulletproof? You absolutely need all 3 to be considered fully compliant. Moving right along to Section 2, the rules for FDI, ECB, and ODI. These are what we call the big 3 transaction types. When we look at these big 3 side by side, the rules become a lot clearer. For foreign direct investment, or FDI, you have to figure out if you're in the automatic route, which is great, no prior approval needed, or the government route, which applies to sensitive sectors like telecom. Then you have external commercial borrowings, or ECBs. This is where you raise funds from foreign lenders, and the RBI places incredibly strict end-use restrictions here. Basically, you can't use that borrowed money for real estate speculation or paying off domestic loans, period. And finally, overseas direct investment, or ODI. When you invest abroad, you're legally bound to file annual performance reports for as long as that investment remains active.
Now startups, listen up. Founders frequently use convertible instruments, but under FEMA, compulsorily convertible instruments are treated as equity. Optionally convertible instruments, on the other hand, those are treated as debt. That triggers those incredibly strict ECB rules we just talked about. Misclassifying this on a term sheet is a massive, painful mistake. Also, if you happen to be raising a down round, you still have to follow strict RBI valuation norms. You can't just arbitrarily lower the price without following the required math.
And if you're an NRI or a resident individual remitting money abroad, maybe for education, medical treatment, or an investment, you need to remember this exact number: $250,000. That's the maximum cap per financial year under the Liberalized Remittance Scheme, or LRS. Staying within these limits and declaring the correct purpose code is precisely what prevents your transactions from getting frozen by your bank's compliance department. All right, Section 3, the mandatory forms you must know. Let's break down the paperwork. These forms are the most visible markers of your compliance, and honestly, deadlines matter just as much as the actual data. Form FC-GPR has to be filed within 30 days of allotting shares to a foreign investor. If shares are transferring between a resident and a non-resident, Form FC-TRS is due within 60 days. Then you've got the annual Form FLA due by July 15th and Form ECB, which you absolutely must file to get a loan registration number before you draw down any of those borrowed funds.
Missing these strict deadlines automatically attracts late submission fees, so maintaining a master tracker for these forms is just a non-negotiable for your finance team.
Which brings us to Section 4, the RBI's monitoring role. Let's talk about the gatekeeper of foreign exchange.
So, you might be wondering, who exactly is watching all this paperwork? Well, it's the RBI, working directly alongside your authorized dealer, or AD, banks. And they are watching things very closely through the FIRMS portal. Because this whole system is electronic and tracks your filings in real time, accurate data entry is more critical now than ever before. The software is literally designed to automatically flag inconsistencies. That means a simple typo in a form can trigger a regulatory alert almost instantly.
But look, let's say you do make an honest mistake. This brings us back to that cooperative theme we mentioned earlier, the compounding mechanism. Compounding essentially allows you to self-correct technical lapses. You just raise your hand, admit the mistake, pay a specified penalty sum, and boom, the case is closed. It saves you from a massive PR nightmare and endless brand-damaging litigation.
And trust me, you absolutely want to rely on compounding early because the stakes for ignoring an issue are incredibly high. If a violation is left unresolved, authorities can hit you with staggering penalties of up to 3 times the total transaction amount. In extreme, ongoing cases, they can even go as far as seizing the connected assets.
Let's avoid that. Moving to Section 5, maintaining ongoing FEMA compliance. Here is your action plan.
To stay clear of those massive penalties, you need a seamless operating procedure. It's a simple loop. Step 1, identify if the transaction is on the current or capital account. Step 2, check if you need the automatic or government route. Step 3, always route through your AD bank. Step 4, hit those filing deadlines we just discussed. Step 5, keep your paperwork tight. And finally, Step 6, conduct periodic internal reviews. If you follow this loop consistently, you turn FEMA compliance from this reactive, stressful burden into a really smooth, predictable business routine.
And about that paperwork, regulators rarely pick fights with well-documented businesses. So, keep your board resolutions, formal valuation reports from registered valuers, foreign inward remittance certificates or FIRCs from the AD Bank, KYC documents, loan agreements, and auditor certificates all locked down. Keep them in a centralized, digitized vault with clear version control so you're always ready.
Because when it comes to FEMA, this quote from our source material really just hits the nail on the head. Prevention remains far cheaper than correction under this law. Building internal ownership between your legal and finance teams, setting up automated compliance calendars, and conducting annual external audits today, well, that's going to save your business an absolute fortune tomorrow.
We're going to end this explainer with a provocative question for your leadership team to think about. When investors open up your books to conduct due diligence, they are absolutely going to look at your FEMA record. So ask yourself, is your business truly investor-ready, or is a hidden form waiting to kill your next deal? Remember, true operational discipline and global growth starts with airtight compliance. Thanks for watching this explainer, and we'll catch you in the next one.